talk to us about death penalty and what the rules are for that in Virginia now.
We get asked that all the time because so much of society thinks eye for an eye. Like, why are we talking about 20 to 30 years? Why are we talking about even life? Why are we talking about these things? He took a life, he should die. What I would say to that is elections matter. And in 2021, when we had those sweeping criminal justice reforms, part of what was sacrificed at that time was not just the jury sentencing, but also the death penalty. So Virginia is no longer a state that has capital punishment.
I'm sure you've seen something like this in the news before. You hear about an investigation that's going on about someone who is murdered, and then you have the police, and then you have the prosecution. It's like what you almost think of when you think of like Law and Order. But what really happens in a situation like that? Because at least my guess for a minute, I'm not an attorney, but my guess is it's not quite exactly what we see on TV. With us is Lyle Carver. He's the Commonwealth attorney for Amherst County here in Virginia, and just finalized a conviction with the Wiggington murder. Lyle, thank you very much for joining us.
Yeah, thanks for having me.
So give us an idea of what the process of something like this is like. Obviously, we've seen a lot in the news about it. Again, from my understanding, it was a year of someone who was missing. All of a sudden, there's a concrete slab. Everybody starts investigating, and obviously, I'm doing a really bad job in summarizing this, but you have a confession, and then you have a conviction. And so kind of give us an idea and a walkthrough about how something like this is put together.
Well, it starts with the investigation. And so in this case, there was a delayed investigation because it's a bit unusual, but the defendant was able to successfully kind of throw law enforcement off the trail by his lies at the beginning. And so in this case, Fred Wiggington lied about his wife just being missing, and he reported her as a missing person. Well, adults are allowed to go missing. I mean, we do have freedom. So if what he said were true, it wouldn't trigger any investigation. And so he managed to buy a little bit of time with that. So summer of 2023, he murdered his wife, but threw law enforcement off the trail. And it wasn't until May of 2024 that the investigation really started. That's when the reports made it back to law enforcement. And then they decided, like, this doesn't really look like a missing person. Let's dig into it a little bit more. And once they did that and kind of pushed through, then the case starts coming together. And so prosecutors aren't very involved on the front end. Law enforcement is supposed to bring us the cases. We're as involved as they really choose for us to be. You know, we help and advise as needed with the investigation. We sign off on search warrants, things like that, you know, kind of help approve things, point people in the right direction, offer advice here and there to help the investigation go until charges. Then once charges come, usually a big packet of information comes from law enforcement. Our file gets started, and we start putting the case together from there.
So what was the piece that made it from this is a missing person to going to, well, there's got to be something more to her just being missing?
Well, with missing person cases, they start with sort of like proof of life things, and they try to find out, is the person truly just like missing? They're voluntarily gone, or could something worse be going on? And it's really difficult in our modern society to not leave a trace. People use credit cards, people use cell phones, people use their name, their social bank accounts. It's just hard to go really off grid. So to make that happen for a long period of time would be surprising. So when complaints started coming back in to law enforcement, again, this was before it got to me, but some of the families started reaching back out saying, hey, it's not like her to miss birthdays. It's not like her to go any length of time at all without talking to us. And it's now been months. Law enforcement dug back in on it and could not find any proof of life. Nothing floating out there that made us think that she just chose to, move to the Himalayas or something crazy. Like there was nothing like that. She didn't go off grid in Alaska. She was gone. So then they dug in there and then just kept working until eventually the concrete slab was really as you mentioned at the opening, that was really how the case broke open.
Yeah, I would say that's a pretty big sign that something happened. That was I told my wife about this, that we were going to talk about that. And she's like, how could anybody think that she was just missing and then suddenly there's a concrete slab? So I'm guessing that was the straw that broke the camel's back.
Yeah, I think that's what hurt any potential defense he would have had is, how do you explain away a 6 foot by 4 foot concrete slab literally up against your house? They wouldn't come there for no reason. It couldn't just appear there, and you not know it. So the fact that there was a concrete slab found over her body, it can't really be anyone else in that scenario. The jury certainly agreed with that. So
right, and so how does that go from that? So you have this bit of evidence. The police investigate, obviously go through that. What was considered enough information for you to move to the next step?
Yeah, so law enforcement needs probable cause to make an arrest. We can't stop at probable cause because that's obviously less than beyond a reasonable doubt. So for a prosecutor to successfully prosecute a case, law enforcement has to continue working with us until we get enough evidence to prove it beyond a reasonable doubt. But the arrest comes with probable cause, and certainly they got to probable cause very easily with the body at the house, and they started putting together the other information. They started reaching out to, following every lead, who she had worked with, talking to family members, who were her last contacts, looking at phone records, looking at Facebook records. I mean, just really digging in bank records, just digging in everywhere, like who's seen her, what's going on. Fred Wiggington spoke to law enforcement several times, thankfully. It's always nice when defendants talk. He spoke several times and did not confess, but he would lock himself into different statements. So if he were to say something about a certain amount of money, well, they can look at the bank records to see if that's true or not. If he says where he was at a certain time, they can look at other records to see, was he there or was he not there? And you just start piecing it together over and over, and started piecing together the inconsistencies in his statements and put together a case where they could eventually charge him with murder.
And so once you have a charge, it, I guess, ends up in the circuit court, and kind of walk us through that process. What does that look like?
Okay. Yeah. So if the charge starts with a warrant in Virginia, on a felony, your first step is a preliminary hearing in the lower court, which is the General District Court or Juvenile and Domestic Relations District Court. So you have a lower court hearing to determine if there's probable cause, to determine if there's enough evidence to go forward to the grand jury and then eventually to trial. So that's the first step. So we put our preliminary hearing on, enough evidence to go forward, and then took it to the grand jury. And again, the grand jury found a true bill, which is what it's called when they say there's enough evidence for the indictment to go forward to trial. So went forward, and then the defense requested a jury trial. So we set the case for a jury trial.
And how long of a process from the beginning of having the true bill till having a conviction? How long does that usually take?
Well, in this case, it was very quick. Defendants have speedy trial rights, and so they have to be tried if they're held in custody within 5 months. They can continue that. We, for the most part, as the government, can't. There are a few things that grant us continuances, but for the most part, we have to try it within those 5 months if they want to be tried within those 5 months, and he did. So his case progressed very quickly. Usually cases of this magnitude, the defense attorneys do not feel like they can prepare it that quickly. So they usually ask for continuances because they want to talk to another expert, or they want to have something reanalyzed, or they just really want to go through the mountains of evidence that is out there for a longer period of time. But that's all strategy for the defense. Here, the defense chose not to do those continuances. I think he was just kind of trying to hold our feet to the fire and see if we could put it all together that quickly.
Gotcha. And I mean, clearly you did. I believe the deliberation was only about an hour. Isn't that correct?
Yeah, just over an hour. It was a very quick deliberation.
It's convincing. And so here's another question I have. When I was reading through this, it was something about him making a statement. So I'm guessing this is after his arrest.
Yes.
To somebody he was in jail with, that he had done it. Am I hearing that correctly? What's the story there?
Yeah, it was very convenient. Again, I think I said it earlier, but we always like it when defendants choose to talk, and it is human nature to talk. And he was not very helpful in his interviews with law enforcement. It's helpful to us no matter what someone says, because we can put it together, and it kind of locks him into some version of the story. But you can't always guarantee a confession. Like I never know if a defendant's going to go that far in their statements. But In this case, he befriended someone in jail and decided to open up to him, and opened up to him and told him more details than I've seen in any other case I've tried in the last, 15 plus years of prosecuting.
And so I'm assuming he just kind of told someone about it. Like, how did that information get to you?
Yeah, so the other inmate he spoke to reached out to an investigator he knew and said, hey, this guy just told me about something. And so that investigator then called Amherst, and then our investigators that very day went over and interviewed him. So it was a blessing.
That's wild. And again, one of the things I was hearing about looking through this is I guess the defense was trying to make this so this was evidence that wouldn't be heard. I don't know what the technical term would be for something like that.
Yeah, so the defense wanted to suppress that evidence just because it was just overwhelmingly helpful for us. And they were successful in suppressing some of it, but enough of it came in that it was enough to pretty well guarantee the conviction, I think. It's hard to get in the mind of the juror to know exactly what they thought, but I would assume that those statements corroborating the rest of the investigation were very powerful in their short deliberations.
What else has happened in this case that most wouldn't understand or wouldn't understand when they're looking at this or from the news side? Like, what else would you say when you hear about all of this? Would you say is different that happened in this case?
Well, the informant was big. The rapid pace was big. The very short deliberation is unusual. And in fact, as a prosecutor, if we have a short deliberation, we actually would anticipate not guilty more often than guilty as charged. And here he was found guilty as charged because the jury would have had the option to find him guilty of second-degree murder instead of first-degree murder. But within an hour, just over an hour, they found him guilty of first-degree murder. So that was a little bit unusual. We're still pending the sentencing. We no longer have jury sentencing in Virginia, so he will have a sentencing hearing coming up later this summer. So we'll see how that goes. But we'll put on.
Explain that to folks. How does that work? How does the sentencing process work if the jury doesn't decide?
Well, I'll tell you the old version. The old version is that citizens of the Commonwealth of Virginia, so you get a jury of your peers, so they would vote or they would deliberate and recommend a sentence. So some of our cases in the past, Commonwealth versus Edward Marshall, which was a murder case from, I think we tried it in 2015, I think. The jury came back and recommended life plus 65 years. They get to recommend the sentence. In 2021, the General Assembly, and a lot of their sweeping criminal justice reforms, decided to take away jury sentencing unless the defendant elects it. And here the defendant did not elect to be sentenced by the jury because juries tend to sentence more harshly, than judges. And so now there's only going to be a sentencing hearing. There is no recommendation coming to the judge from the jury on the front end. So we'll see what the judge chooses to do after he'll get a full pre-sentence report. So after someone is pleads guilty or is found guilty, the judge can order a pre-sentence report, which is a probation officer is going to look into everything. They're going to give a bunch of social history on the person, their criminal history, educational background, substance abuse, or lack of substance abuse issues, either way. Good, bad, and ugly. Try to give the judge a full picture of the defendant so the judge can make a decision. Also, as part of that are sentencing guidelines. So in Virginia, the judges get a recommendation of where they should sentence. They can sentence below the guidelines. They can sentence above the guidelines. But if they do either of those, they have to explain it. If they sentence within the guidelines, they just pick a number within the guidelines. So the judge this summer will have sentencing guidelines, and he will get to sentence. And, we will likely ask for above the guidelines, and the judge will either choose to go with us or he will choose to sentence within the guidelines. And that's his call. He wears the robe. He's the analogy we use is the umpire. He's the one calling balls and strikes. So, we'll represent our side and defense will represent theirs, and the judge gets to make that tough call.
What would the guidelines be in a circumstance like this?
Yeah, so first-degree murder are going to have more significant guidelines. The range of punishment for first-degree murder is 20 years on the low end to life imprisonment on the high end. He also was found guilty of use of a firearm, and that just carries 3 years mandatory. You can't get more than 3 years. You can't get less than 3 years. It is 3 years mandatory, and you pull every day of those 3 years. So he will get 3 years plus 20 to life, depending on what the judge sentences. I haven't seen the guidelines yet because the probation officer will run those, but they're probably going to be a low end in the low 20s to a high end, upper 30s to 40, somewhere in that range will be those guidelines. But it's the advantage of from a prosecutor standpoint, from a first degree conviction to second degree guidelines are lower.
And talk to us about death penalty and what the rules are for that in Virginia now.
Yeah, we get that's a common question I get a lot. We get asked that all the time because so much of society thinks like eye for an eye. Like, why are we talking about 20 to 30 years? Why are we talking about even life? Why are we talking about these things? He took a life, he should die. I hear that constantly when any murder trial comes up. That is the most common question I get. And what I would say to that is elections matter. And in 2021, when we had those sweeping criminal justice reforms, some of which might have been needed or helpful, but most of which were, from my perspective, a little bit overreaching, and maybe not fully thought out at the time. When those things were done, part of what was sacrificed at that time was not just the jury sentencing, but also the death penalty. So Virginia is no longer a state that has capital punishment. And it was difficult to get capital punishment anyway, even when it did exist. But in Virginia since 2021, it does not exist. And so about half the states, maybe just over half, still have the death penalty, but kind of a trending away from it. And the federal government also still has the death penalty, but Virginia does not. So what we have now is called aggravated murder. And aggravated murder is first degree murder plus something. It takes something to aggravate it, something to enhance it. So it could be killing multiple people.
You know how ridiculous that sounds, right? What's more aggravating than shooting somebody? And in this case, my understanding is like execution style murder. How do you make that more aggravating?
Yeah, and that is what we proved at trial. It was sort of an execution style, shot in the back of the head, and then buried right there at the house. Like from a layperson standpoint, someone who isn't bound by the law, just bound by what you think is right, what you grew up with, your just moral beliefs. That sounds like a death penalty case to people. But Virginia law no longer allows that. So it requires a very specific list of aggravating factors. Killing someone in custody, like if an inmate kills another inmate, that can be a death. Well, what could have been a death penalty, that could be aggravated murder case, rape plus murder, multiple murders, things like that. It's not just an automatic first degree murder, death penalty. That historically, yes, but not Virginia law since 2021.
Well, what else would you like to add? I'll give you the final word on this, something that, maybe people have common misconceptions of with how the Commonwealth attorney prosecutes cases. Yeah. What would you like to say?
Okay, so a few thoughts, and I'm sure as soon as we get off, I'll think of other things I should have said, but a big thing.
Have you come on again?
That sounds great. A big thing is that trials in Virginia are public. Don't just get your information from social media. Don't just get your information from local news channels. Come watch court, participate in court. If you get called to jury duty, don't find some excuse to get off jury duty. Serve as a juror. That's the way our system works. And our system is imperfect for sure, but it's the greatest in the world. So, and the only way to make it better is to participate in it. So I would just challenge people to be involved. Come and watch court. A few of the things in juvenile and domestic relations court are closed to the public. Virtually everything else in general district court and in circuit court is open to the public. Come watch these trials. Come watch these sentencings. Come see what happens in court. It is not what you see on TV. It will not feel like an episode of Law and Order. It will not feel like CSI. It will not feel like that. But you probably will get a better grasp of what's going on. You probably will have a good feeling for the players involved and how things are going and what's going on in your community. I would just really challenge people to kind of get involved in that way and kind of see it for yourself.
Awesome. Thank you very much for your time.
Yeah, thank you so much.